Good morning, everyone, and welcome to our session on Your Will, Your Way. Today's session is led by Linda Hart, a principal here at Hunt & Hunt, known not just for her sharp legal mind in wills and estates, but also for her mixology skills. You might recognise her as the host of Wills and Spills, where she busts legal myths while shaking up a cocktail. And yes, she also runs half marathons, but she's full of commitment when she's out there and often gets others in here at Hunt & Hunt to join her for a charity run. But you're not here for running or cocktail advice. Linda has been practicing in wills and estates for the best part of 2 decades and is an accredited specialist in wills and estates and an acknowledged leader in a profession with many years of experience in will disputes, and she also leads our wills and estates team. She's also the president of Victorian Women Lawyers. We'll have time for a question at the end. Please use the chat function to load them. I will monitor those and pass them on to Linda as the session goes on, and she will deal with what she can at the end of this session. So now, please welcome Linda.
Thanks, Andrew. Good morning, everyone, and thank you for joining me on this webinar, Your Will, Your Way, and why every woman needs a will. Now, what do all these celebrities have in common? Amy Winehouse, Prince, Jimi Hendrix, Billie Holiday, Barry White, and James Dean. Now, Amy Winehouse, R&B singer, died at the age of 27. She did not have a will. Therefore, her parents ended up inheriting her $6.7 million estate. There was a suggestion that she did not get along with her father, and if she had a will, it would not have gone to him. Prince died at the age of 57. He did not have a will. His estate was worth about $300 million. He died with no partner, no children, or even surviving parents. He had one full-blood sister. Now, at least 700 people claim to be Prince's half-siblings, and if true, they would have a claim on his estate. Jimi Hendrix, he died at the age of 27. He did not have a will. The fight over his estate took more than 30 years. Eventually, his father inherited all of his estate. Billie Holiday, a legendary jazz vocalist, died at the age of 44. She did not have a will. She was estranged from her fourth husband, but they weren't divorced at the date of death. This allowed him to inherit her entire estate, including royalties. Barry White, he died at the age of 58. He did not have a will. The famous soul singer, ex-wives, girlfriends, and children were left to squabble over his multi-million-dollar estate. James Dean, the Hollywood icon, died at the age of 24. He did not have a will. According to California law, it directed his assets to pass his closest surviving relative, which was his father. However, James was raised by his aunt and uncle, and it's likely if he had a will, he would have preferred his estate to go to them and not his father. What these celebrities also had in common was that they caused their family a lot of pain, stress, and sorrow because they were unprepared by not having a will. Instead of the families grieving together, they were torn apart with lawyer fees and lengthy court appearances and appeals. It is essential that every adult has a will, but it's even more crucial for women. Statistics show that women are living longer than men. Women are financially independent and building a nest egg for themselves. Many of the women are the co-breadwinners, if not the breadwinner in their relationship. As a result, women will be in a position where they'll have greater financial wealth and when they pass away, and that's why it's essential for them to have a will. I want to focus on what happens if you don't have a will. Now, I'll take you through the chaos, the confusion, and consequences of dying without a will. In particular, I will discuss the chaos of not appointing an executor to the administrator of your estate, the confusion of who cares for your children, pets, and lack of direction about your end-of-life wishes, and the consequences of inheritance passing to your chosen beneficiaries, or not passing to your chosen beneficiaries. I will start off by looking at the chaos. The chaos of not appointing an executor. Now, in all wills, you are required to appoint someone to be your executor, or you can appoint a couple of people to be your executors. The role of the executor is to carry out the wishes of your will and administer your estate. This involves calling in the assets, paying all the debts of your estate, and distributing the estate to the beneficiaries in accordance with your will. Now, if you don't have a will, it means you haven't appointed an executor to administer your estate. Therefore, someone will need to apply for the role to be the administrator. In Victoria, the order of priority determines the most likely administrator is a spouse or domestic partner, followed by your adult children, then parents, then siblings, and failing that, your extended family members. The application is referred to as letters of administration. Now, once the court makes the grant, that person becomes the administrator of the estate and has the same rights and responsibilities as an executor. By not appointing someone to administer your estate, this causes delay and additional expenses, especially if the court has to determine who is the appropriate person to be appointed as administrator. Now, in the case of Rhea Memos, the deceased tragically died from a stroke when she suffered while playing football. She was only 23 years old, and not surprisingly, she did not have a will. Her parents applied to be the administrator, and they obtained a grant of letters of administration. Now, Laura made an application to the court to revoke the grant of letters of administration on the grounds that she was a deceased domestic partner and had greater standing than the parents. In support of her application, she filed 2 affidavits made by her, as well as 7 affidavits made by friends of hers and the deceased. Now, to enable the court to determine whether Laura had better standing to apply to be administrator, the court had to determine whether Laura was a deceased domestic partner. In the Administration and Probate Act, a domestic partner is a person who, although not married to the person, was living with the person at the time of the person's death as a couple on a genuine domestic basis, irrespective of gender, and either had lived with the person in that manner continuously for a period of at least 2 years immediately before the person's death. In determining whether a domestic relationship exists or existed, the court looked at all the circumstances of the relationship, including any one or more of the following matters as relevant in a particular case. So the court looks at the degree of mutual commitment to a shared life, the duration of the relationship, the nature and extent of common residence, whether or not sexual relationship existed, the degree of financial dependence or interdependence, and any arrangements for financial support between the parties, the ownership, use, and acquisition of property, the care and support of children, and the reputation and public aspects of the relationship. The parents argued that Laura and the deceased were only university friends and roommates. Their evidence was that the deceased was never told that she was in a relationship with Laura, and they did not know she was gay. However, the parents could not contradict the evidence provided by Laura, as they had not had any contact with the deceased for at least 2 years before she passed away. The court was satisfied that Laura was a deceased domestic partner and that it was appropriate for the court to exercise its discretion to revoke the grant made to the deceased's parents. The Laura became the administrator of the deceased estate. Similarly, in Yasovich and Nosovich, the deceased died without a will. He did not have any children. Now, under the laws of intestacy, his nephew was the sole beneficiary and was granted letters of administration. Rada made an application to the court to rewrite the grants of letters of administration on the basis that she was the deceased partner. The nephew argued that Rada and the deceased was not a domestic partner, as they had separate living arrangements and finances, and Rada was the deceased carer. In determining whether a domestic relationship existed, the court looked at the same factors as they did in the previous case. Now, the court observed that separate living arrangements, the separation of finances, and the assumption of a carer role are not evidence to displace the existence of an otherwise genuine domestic relationship. The court found that Rada and the deceased had a loving, committed relationship, which was observed by third parties to be a genuine domestic relationship, and granted new letters of administration to Rada. Now, disputes can also arise in situations where multiple people have equal standing to apply to be administrator. I had a case where the deceased died without a will. He was survived by his 3 adult sons. All 3 sons applied to be the administrator and was granted letters of administration. It was a very large estate, approximately 15 million, comprising of numerous properties, share portfolio, and various other assets. There was a dispute about how they were to administer their father's estate. I acted for one of the sons. Now, each of the brothers had their own lawyers acting for them because they couldn't get along. As a result, there are 3 sets of legal fees, which was unnecessary as one lawyer should have been engaged to assist them with estate administration. This went on for over a year. Now, due to the continued disputes between the brothers, in the end, an application was made to the court to remove all of them as administrators and appoint an independent administrator. This chaos could have been avoided if the deceased had made a will. As you can see, the above cases highlight the importance of having a will and appointing an appropriate person to be the executor. As you can see, it may not be desirable to have all your children as executors. The question I often ask clients is, well, do your children get along? Now, in some circumstances, it might be appropriate just to appoint one child as the executor, or you may want to appoint a sibling to administer the estate. Perhaps a friend is more appropriate. There are many dynamics in families, and sometimes it might even be preferable for a third party to be involved in the administration, such as appointing a trustee company or your accountant or even your solicitor. I will now move on to the confusion of not having a will. There's no influence in who cares for your children. If you have a will, you can nominate someone in your will as a guardian of your minor children. Nominating a guardian ensures that your wishes as to who should take legal responsibility for the care and parenting decision of your children are known, particularly in the event where both parents unexpectedly pass away. Now, being appointed guardian on a will does not make the direction binding on the family court, but it does mean that the guardian is entitled to be part of any proceedings in determining the child's guardianship, including challenging any parenting order already made. The family court would generally consider the child's best interest when making any decisions. If you don't have a will and both parents pass away, any person with sufficient interest, including grandparents, aunts, or uncles, can establish a formal guardianship arrangement by applying to the family court and making their case as to why they are suitable. In such situation, it's up to the family court to decide who should become the legal guardian of your minor children. The family court may appoint a person who is not the person you want to raise your children. But if you had a will and appointed a guardian, at least that document is before the court and the judge will know your intentions and he or she will take that into consideration and try and affect your wishes. You have no influence in who cares for your pets. Many of us have pets, and more people are now opting to have fur babies instead of children. So it is important that they are cared for once we are gone. People assume that relatives or friends will step in to care for their pets, and that's not always the case. As we know, pets can be expensive with vet bills and food, and often people may not have the means or time to take on a pet, and many pets end up in animal shelters. There can also be disputes about who receives a family dog or who gets the cats or the birds. Without a will, the responsibility passes to whoever might be the administrator of your estate to decide what happens to your pets, and it may not be in line with what you want for your pets. Without legal direction, your pet's future is uncertain. I've heard many people make wills leaving their estate to their pets. However, this wouldn't be valid in Australia, as animals unfortunately are treated as property. Look, you may not be able to leave your estate to your pets, but there are other steps you can take to ensure that your pets are appropriately cared for when you pass away. If you have a will, you can gift your pet to a family member or friend or to a charity. So a pet can be gifted to a beneficiary. This might be a family member or a friend. As with any gift, the beneficiary has the option to refuse. So it is important you speak with your chosen beneficiary while you're preparing your will. Or if you don't have anyone take care of your pet, you could consider gifting it to an animal welfare shelter, which will then undertake to rehome it and look after its ongoing care. You can also gift your pet with a lump sum of money. Now, this is probably the most common way. As pets are expensive, you can gift money as well as gifting your pet. The third way is you can gift your pet with an established trust. You can establish a trust under your will with the express purpose of providing for your pet over their lifetime. The trust is created in the name of the beneficiary you have nominated to care for your pet. In this situation, they become the trustee. They're responsible for looking after your pet and they're legally responsible for using the funds set in the account for your pet's care. Now, if you are going to make a direction for your pet, your will must be clear and careful drafting is required to ensure that your wishes for your pets are fulfilled. And this was seen in the case of Habit and Zaid. Now, the deceased, when she died, was living alone with 2 cats for company. The deceased loved her cats, which she named Bonnie and Clyde. In her will, the deceased made a gift of her home to her closest friends, Christopher and his wife, Lorraine, in return for caring for her 2 cats. The clause was as follows. I give to my dear friends my freehold residence of Tennyson Point, together with all personal effects contained therein in return for caring for my 2 cats. Now, a dispute arose as to interpretation of the gift clause in the will. The court was asked to determine if the gifting of the house to the friends was conditional upon them caring for the deceased cats, or did the friends inherit the house absolutely, and it was merely a wish of the deceased that they had cared for her cats. The court ruled that the clause was ambiguous, and to enable them to determine the deceased's intentions, the court referred to the solicitor's file notes who prepared the will. Now, the file notes recorded conversations where the solicitor expressed concerns regarding how vague the clause was, and he sought clarification. He raised concerns with the deceased and asked her, what if the property is transferred to your friends and they don't look after your cats? Now, according to the file notes, the solicitor asked the deceased if she wanted him to redraft the clause to make it conditional. The deceased, however, maintained that the clause should be kept as it was and that she trusted her friends as they promised her that they'll look after the cats. Now, the court determined that the deceased did not intend to make the gift of the house conditional upon caring for the cats. So the court decided that the requirement for the care for the deceased cats did not have to be met for the friends to receive the house. It ruled in favour of the friends, giving the house to them unconditionally. There's also the confusion that you have no influence in your end-of-life wishes. It's not uncommon to see disputes arise between family members about whether their loved one should be buried or cremated. When clients pass away, we regularly receive calls from their family asking if they provided direction in their will for their funeral. And often clients do provide this in their wills to ensure their families know their wishes. If you have a will and it does not provide direction, under common law, an executor nominated on the will has exclusive authority to take possession and custody of the body for the purpose of its disposal. This was seen in Gus Cake and Alison Sarah Cake. The New South Wales Supreme Court had to resolve a dispute between a Roman Catholic widow and her Muslim brother-in-law as to who had the right to decide on the form of funeral for the deceased. So the deceased was born in a Muslim faith and later adopted Catholicism. During his lifetime, he adopted both faiths. The deceased was married in a Catholic church, where his widow wished his funeral to be held, but this was strongly opposed by the deceased brother. He thought that he be buried in accordance with Muslim tradition. The deceased did not provide any direction in his will regarding his funeral, but he had appointed his wife as executor. The court ruled it was not in a position to assess the relative strengths of the deceased's faith or loyalty to the respective religions. The court made a decision in favour of the wife and confirmed that the executor has the right to dispose of the body and decide where and how it is to be buried or cremated. Now, people often don't start thinking about their funeral or end-of-life wishes until late in life, unless they become terminally ill. But dying without a will risks your end-of-life wishes getting lost amid the overwhelmed grief. If you don't have a will, as mentioned earlier, the next of kin, such as your partner or child or parent, can make an application for letters of administration. Once appointed, that person becomes administrator of the estate and has the right to determine the deceased's funeral arrangements and to dispose of the body. Now, leaving the administrator to decide your funeral can add stress to your family and it can lead to disputes. For example, in a Western Australian case, a teenager tragically died and there was a dispute in relation to funeral arrangements and disposal of the deceased remains between the deceased's estranged mother and his sister. The mother wanted the deceased to be buried, but his sister wanted his body to be cremated. The deceased died without a will, and there was no direct evidence about whether he wanted to be buried or cremated. A sister told the court that cremation was a normal approach in her extended foster family. She also had a closer relationship with the deceased than the mother did to the deceased. The court ruled in favour of the deceased sister that he be cremated. There are also disputes regarding the deceased's ashes. Now, in the case of Wang and Zhang, number 2, the deceased was survived by his second wife, Yu Qin, his daughter who he had with Yu Qin, and his adult son from a previous marriage. Now, when the deceased died, his son organised a funeral service and took possession of the deceased's ashes. The deceased died without a will, so Yu Qin applied for letters of administration, but the deceased son objected on the basis that the deceased had left, we call it the purported will. Now, pursuant to this purported will, the deceased appointed his son as executor of his estate. The deceased's assets in Australia were to be distributed between 6 people, including his son and the deceased's former wife, and that his son will be given sole direction on funeral arrangements and that other family members are not to interfere. In addition, the deceased son submitted that he and the deceased entered into a property transfer agreement, which included a statement by the deceased that the son would decide how to deal with his ashes. Yu Qin disputed the genuineness of the purported will and the property transfer agreement and claims that both were forgery. The court acknowledged that the general rule is that the person named as executor under the deceased's will has the right and authority to dispose of the deceased's body. However, the court found the evidence produced was sufficient to establish suspicion that the purported will was not genuine. The court also had doubts about the legitimacy of the property transfer agreement. Due to this, the court deemed the appropriate person to deal with the deceased's ashes to be the one who is likely to have been the closest to the deceased late in his life, and as such, be invested with their trust and confidence. At the date of death, Yu Qin was living with the deceased and they were married and had been together for 12 months, living together for 12 months. As such, the court determined that it would be in line with community expectations that the spouse of the deceased should have authority and control of their partner's remains. Therefore, Yu Qin was the appropriate person to have responsibility of making decisions about the most appropriate way to deal with the deceased's ashes. On that basis, the court ordered the deceased's son to give the deceased's ashes to Yu Qin. She had the right to deal with them in her sole discretion. Similarly, in Damon and Damon, a recent case in New South Wales, the court had to resolve a dispute between a deceased's estranged daughter and a deceased's long-separated wife in relation to funeral arrangements and disposal of the deceased remains by cremation. In that case, the court ruled that the ashes be divided between 3 family factions, including the daughter and estranged partner. So disputes like this does happen, and it's best to have a direction in your will to avoid this. Instructions over burial and your funeral arrangement will provide strong evidence of your intentions should your executor choose to ignore your wishes or a dispute between family members arise and the court needs to step in and make a final decision. Lastly, I'll look at the consequences of not having a will. Inheritance not passing to a beneficiary of your choosing. If you die without a will in place, you are considered to have died intestate. Now, this means that the law determines how your estate is passed and who will manage it. Some of you may be familiar with the Liam Payne's case in the UK. Now, Liam Payne was a British singer in One Direction who died at the age of 31 after tragically falling off a hotel balcony in Argentina. Now, he was survived by his partner and his 8-year-old son from a previous relationship. Documents show that the court granted power of administration of his estate to his former partner, the mother of his son. Under UK's rules of intestacy, Liam's son inherits his entire estate, while his partner will receive nothing as they were not married or in a civil partnership. Now, of course, he would have wanted to provide for his son, but he may have also wanted to provide for his partner. But unfortunately, under the UK rules of intestacy, she misses out. Now, in Australia, each state and territory has their own intestacy laws, which dictates how your estate will be distributed. And no, it doesn't all just go to the government. Now, I prepared a flowchart which shows intestacy rules in Victoria. So if you pass away without a will, if you leave a spouse or partner and no children, your partner will be entitled to your whole estate. If you have a partner with children of that relationship, your partner is entitled to your whole estate. Now, if you have a partner with no children of that relationship, but you have children from a prior relationship, then your partner will receive all the personal assets plus a statutory amount, and this gets indexed each year, and plus half of the residue of your estate, and your children will receive the other half equally. If you're in a situation where you have no partner or children, then it will go to your parents. If you have no surviving parents, then it will go to your siblings, and if they don't survive, to their children. If no surviving siblings or nieces and nephews, it goes to your grandparents, aunts and uncles, cousins, and then lastly, it will go to the government.
That's right.
Now, there may be people out there who are content with their estate being distributed in this manner, but let me give you a few scenarios. What if you are in a blended family situation and you have stepchildren? Intestacy rules do not provide for stepchildren. It only provides for biological children or adopted children. So if you are in a relationship where you have stepchildren, if you pass away without a will, under laws of intestacy, they will miss out. Similarly, if your partner passed away without a will and you had children from a previous relationship, your children from that previous relationship will not receive anything from the state under the laws of intestacy. Or what if you're in a situation where you don't have a partner or children, but you're estranged from your parents? Without a will, your estate will pass to your parents equally under intestacy. I had a case recently where the deceased died intestate at the age of 34. She was single and had no children. She was survived by her parents. She had a very close relationship with her mother and had no contact with her father. Unfortunately, under the intestacy laws, her estate was just distributed equally to both parents. Now, if she'd made a will, she could have left it all to her mother. Or you might be in another scenario where you're going through a separation with your spouse and you're in the process of filing for a divorce. By the time you passed away, the divorce had not yet been finalised. If you didn't have a will under the laws of intestacy, your estate would be distributed to your spouse because at the date of death, you are still legally married. Now, I've dealt with a few cases in this situation. So in one of the cases, the deceased was survived by his 2 adult children. So under the laws of intestacy, if the deceased did not have a spouse or domestic partner, his estate is distributed to them equally. The problem in this case was that at the date of death, the deceased was still legally married as because he never bothered to formally get divorced, despite the fact that him and his wife had ended their relationship 30 years ago and had moved on into new relationships. So at the date of death, his wife was legally entitled to his entire estate. I acted for the children, and the wife agreed to give up her entitlement, and we prepared a deed of family arrangement formalising this. Now, this could have turned into a big litigation fight if the wife was not cooperative. Still, there was unnecessary legal costs incurred by the states and delayed in the administration. It would have been a lot simpler if the deceased made a will or formally got divorced. Now, as mentioned, each state and territory has different intestacy laws, so it depends on where you live. However, it becomes complicated if you live across different states within Australia or even overseas. It is further complicated if you own property in different jurisdictions. So then the question becomes which law applies in this situation where there is a conflict of laws? That is, how will your estate be distributed? It is often determined by whether the assets are movable or immovable property. Now, movable property generally is property that is attached to that is not attached to land, such as a bank account. Immovable property is property that's attached to land, such as parcel of land and its fixtures. So the general rule is that the law of the place where the immovable property is located applies to that immovable property for the purpose of intestacy. And movable property, the law is where the deceased is domiciled at the date of death. Now, this was explored in the case of Rian Tan. So the deceased was an Australian citizen, but at the time of his death, he was domiciled in China. Now, the date of his death, the deceased had assets in Australia, which consisted of 2 bank accounts held with Westpac and a motor vehicle. His remaining assets were in China. The deceased was survived by his father and his mother and his wife, who he was separated from. His parents were divorced, with his father living in China and his mother living in Victoria. While he was sick, the deceased wrote a note purporting to leave his Australian bank accounts to his mother, who was in China at the time he made this note. His mother applied for letters of administration in Victoria. Now, the court had to determine what laws are to be followed to his Australian assets. Was it China or Victoria? The Court of Appeal in Victoria found that the relevant law that applied, due to the deceased domicile at the date of death, and due to the fact that the property in Australia was a movable property, it was the Chinese law. The note was determined to be valid under Chinese law, and the deceased mother could apply to have these bank accounts released to her. The remaining property was to be distributed in accordance with the laws of intestacy in China. The consequences of not providing for certain beneficiaries. Now, there may be people in your life that you wish to provide for. For instance, you may be a carer for your siblings, so you want to ensure that he or she is provided for in the event something happens to you. Or you might be raising your niece or nephew, so you want to make provision for them if you're not around. Unfortunately, if you don't have a will, these people don't automatically receive under the laws of intestacy. Scenario 1, providing for siblings. I have a friend who currently doesn't have a will. She's in her late 30s, single and no children. She's not bothered by not having a will because she said, according to the laws, her estate will be distributed to her siblings equally. Well, she missed a step. If she passed away without a partner or children, the next in line are parents. Now, she lost her mother when she was in her 20s and didn't really have a relationship with her biological father, as he left her when she was young. But that's irrelevant because according to the law, provided that he's still alive, her father will be entitled to her entire estate if she passed away without a will. It would only go to her siblings if he had passed away before her. Scenario 2, providing for your friends. Now, you may not be in a relationship, you may not have a good relationship with your family, and you may be closer with your friends who you consider as your family. But under the laws of intestacy, your friends will not receive anything. A few years ago, I prepared a will for a woman who had cancer. Now, by the time I saw her, she was already at stage 4. She did not have a partner or any children, and her parents had already passed away. Now, without a will, under the laws of intestacy, her sister would receive her estate. She was adamant that she did not want her sister to receive anything. Her good friend had been there for over the years and had supported her. She wanted to ensure that her friend received her estate when she passed away. A few weeks after signing her will, she sadly passed, but her wishes were upheld and her estate was distributed to her friend in accordance with her will. Scenario 3, now providing for a child that has needs. You may have children where one is in more need than the other, and you want to make provision for that child. If you don't have a will, under laws of intestacy, your children would receive an equal share. I had a situation like this. So the deceased was survived by his 3 adult sons and 1 daughter. The deceased daughter was disabled and she lived with the deceased in their family home her whole life. Now, due to her disability, she was unable to work and her only income was government benefits. She was single and had no children and no assets. Whereas the deceased other children were financially secure, running their own businesses, owned their own homes, and a few of them even had their own investment properties. The deceased died without a will, and therefore his estate was to be distributed equally to the 4 children. This was not a large estate. The main asset was a family unit valued at $300,000. So they could either sell the family home and distribute the sale proceeds between 4 of them, or they could all go on title and each of them own an equal share. This would not have been what the deceased would have wanted. He would have wanted to make more provision for his daughter to ensure that she was adequately provided for during her life. The deceased sons also recognised this and wanted to look after their sister, so they entered into an agreement to give up their entitlement in the properties that could be transferred to her. This was not a straightforward process, as there were stamp duty implications and legal costs, which all could have been avoided if the deceased had prepared a will. The consequences of increased risk of estate dispute. Now, by not having a will in place, you do increase the risk of your estate being challenged. I have friends who say, I don't need a will if I die because it will go to my partner. Yeah, sure. But what if your family don't consider that person to be your partner? This is where issues arise. By not having a will, it increases the risk of estate disputes. I've also dealt with numerous cases in these situations. Now, the first case, I had a young woman, 27 years old, who died tragically in a car accident. She was survived by her partner of 9 years. I acted for the partner. Under intestacy laws, her partner was to receive her entire estate. The woman's parents challenged the partner, arguing that he was not the partner and was only a friend. If the parents could establish that he was not the partner, the parents stood to receive her estate. The partner told me that they had been together since she was 18 years old, and their families knew each other very well and often went on holidays together. The families were also aware that he was going to propose to her on their next holiday, but the parents continued to argue that he was not the partner. This case took a toll on him, and he couldn't properly grieve his partner as he was fighting with her parents. If we had proceeded to a trial, it is likely he would have been successful in establishing he was the partner. But the litigation was too emotional for him, and he gave me instructions to make an offer to the parents and settle the matter. I had another case where the deceased had committed suicide. He was only 36 years old. I acted for his partner. She had been with him for 6 years. They lived together. They talked about having children and building a future together. He died intestate, and therefore his estate would be distributed entirely to her as the partner. His parents also argued that she wasn't the partner and somehow blamed her for his death. It took an emotional toll on her as she had to prove her relationship. She also eventually settled with his parents. Now, in both cases, it was clear that the parents were aware of the relationship, and there was no dispute that their children were in genuine domestic relationships. But for whatever reason, it could be from grief of losing their child, or could be because of the money. But disputes arise and the relationships were questioned. Blended families are a lot more common now, where there are stepchildren. And as we know, under intestacy, stepchildren are not entitled to receive a share in the estate. So in this case, the deceased husband died in 2017. He had a will that left his entire estate to her, and in the event she did not survive him, his estate was to be distributed equally between his son and 2 stepchildren, which were her children. Now, she died in 2021 without a will. She was survived by her 2 biological children and 1 stepchild, which was her late husband's son. Under intestacy, her estate distributed equally between her 2 biological children. So the stepson brought a claim for further provision from her estate. The stepson argued that the deceased had a moral duty to provide for him. He also argued that his father's will passed to her, and he did not make a claim on his father's estate because he thought the deceased would provide for him in her will. The stepson could also demonstrate that he was in financial need, and this case successfully settled at mediation. Now, there's also the flip side where people come out of the woodwork when someone has passed away and claim that they are the deceased partner. Now, this was in the case of Ree Gunn, Thomas and Gunn. The background in this case, Sandra died on the 28th of March 2019 without a will. At the date of death, she was not married and had no children. Sandra was survived by her mother and father. So under the laws of intestacy in Victoria, Sandra's parents would be entitled to the whole of her estate. Now, Gavin issued proceedings in the court on the basis that he was Sandra's domestic partner. If he could prove that he was Sandra's domestic partner, he would be entitled to the whole estate and Sandra's parents get nothing. Gavin alleged that he'd been in a relationship with Sandra since February 2017 until she had passed away. He claimed that he intended to ask Sandra to marry him and he had given her a ring. He also filed affidavits from their shared counsellor and 4 friends who stated they were in a loving relationship. The court found that Gavin's evidence fell short and he did not demonstrate that he and Sandra were living together as a couple on a genuine domestic basis. There was no evidence that they had a joint bank account, engaged in any joint investments, or acquired any property jointly. There were no arrangement for financial support or contributions. Therefore, Sandra's estate was distributed equally between her parents. Now, again, this situation could have been minimised or avoided if Sandra had made a will. As you can see, these cases have demonstrated if you don't have a will, it creates uncertainty and havoc between the family. I hope I have convinced all of you, if not most of you, as to why you need a will. If you leave it to the laws of intestacy, you have no control over who administers your estate. You have no say in who's the guardian for your children or who will care for your pets. You have no control over who benefits from your estate and the proportion in which they benefit, and there may be disputes as to who is your next of kin. So avoid the chaos and the confusion and consequences and ensure you make a will today. So are there any questions?
There are no questions in the chat line, Linda. So I'll, unless somebody's got any questions, I can.
I'm happy to take a live question if someone's got a burning question, or you can certainly obviously contact me after the webinar. No? Okay, great. Thank you everyone for your time. I hope you got something out of this, and feel free to drop me a line or if you have any questions or concerns. Thank you so much.
Oh, Linda, we did just have one question come through.
Oh, yeah.
So from Rosemary, said her husband made a will in Queensland and has now moved back to Melbourne. Does he need to make a new will?
Are his assets, where are his assets?
That's a very good question. Maybe I should unmute.
Happy to take that off. In Victoria.
They're here. Just the assets are here, yeah.
I always say to clients, if you've now moved jurisdictions, I would make a new will. But his will is still applicable, but I always make a new will if I've moved.
Cool.
What's
Thanks. And there's one from Sarah.
Yep.
Asking who pays for the estate. When does the estate pay for the litigation?
Well, the states, if you're talking about disputes, so in all litigation cases where there's a dispute, it does come out of the state, and that's normally negotiated at mediation.
All the questions are flowing now. How and where do we start to make a will? Question mark.
How and where do we start? The best thing is to obviously contact a solicitor and get a solicitor to take you through that process. Please do not get a will kit. I litigate numerous will kits. And if you are going to go and see a lawyer, please also go and see a lawyer that works in wills and estates. I've also litigated numerous wills that haven't been drafted properly from lawyers who don't practice in our area.
And here's a perfect one for you, Linda. Even if you have a will, can your wishes still be challenged successfully?
Oh, yes. But the question I get asked all the time, look, there's no bulletproof will, but it does minimise challenges. So it's better to have a will than not have a will. So yes, to answer your question, of course, any will can be challenged, but the better drafted the will is, the less likely it can be challenged.
Yes, and one last one from Marilyn, who doesn't have any family members in Australia who can act as trustees of her will. What options does she have?
Yeah, you can appoint someone here. You can appoint your solicitor, you can appoint a friend. You can appoint a trustee company. You just have to appoint someone that you trust to manage your estate. It's all about trust, someone that you trust to do it.
It doesn't look like there are any more questions. So with that, we can, hang on one more. I've heard about testamentary trusts. How do they work and what are the benefits of including them in a will?
Well, so from Jamie, that's another whole webinar. There's lots of benefits of testamentary trust. Look, I'm happy to send you an email with some information about that.
Excellent. And the last one for basic family, no drama, tested, jumping around a bit, tested husband, beloved parents and kids, do I still need a will?
Yes. Even if you're happy for your will to your estate to be distributed under laws of intestacy, please get a will because disputes arise all the time.
Yes. Another one, can you provide more information about an only adult child living with a disability? I assume they're after what
I can do
provisions
that
need to be made.
offline. Yeah, I'm happy to give you some more information about that offline.
What is the cost of making a will? There you go. There's the juicy one.
Also the question, it varies between firms. I mean, I've heard some firms say they charge, $200 or $150. So it does vary. I mean, our firm charges a bit more than that, but yeah, it varies. But the cost of making a will is worth it compared to all the legal costs you would if people are disputing it.
Yes, I think if we refer back to the one where they asked the question about whether a will can be contested successfully, you do get what you pay for, is the bottom line. Yep. One last one from Kirsten. Can your 2 adult children be left 1/4 each of your property and the other half to your husband?
In a will, you mean, or?
Yeah.
Yeah, you can do whatever you want. You can distribute whichever manner you want in your will. It's up to you.
All right, we got a thumbs up for that one. Right, that should do us. We'll close that one down now. Thanks, Linda. Remember the contact details are there for Linda on the screen. If you scan the barcode before I close down the session, it will actually transfer Linda's contact details to your telephone. So yeah, last chance to scan the barcode, or obviously just look up Linda on the Hunt and Hunt website.
Thank you.
Thanks for joining. Yeah, and thanks for joining us.
Thank you. Bye.